Okay, this email is from, well, can't use your real name, so we're going to call you Shaniqua. This is from Shaniqua. Hi there. I have a few questions regarding your fees in a DUI case. Here is a little info. So, adult, Tacoma, no priors, BAC that's not too high, not too low. Pulled over for a cracked windshield, cooperative. And your question is, could you give me an estimate of how much you would cost to defend me, as well as the expected outcome you would expect to see after my hearing? Well, Shaniqua, thank you very much for sending me this question. There are a lot of variables here. So here's what typically happens in a DUI, and here's the pitch I would give you if you were here in my office. The cops pulled you over, and first they have to have a good reason for pulling you over. After they pulled you over, they have to have a good reason to expand the stop into a DUI investigation. And they usually do that. They say that they smell alcohol and you have watery, bloodshot eyes, your speech is slurred. When they ask you for your driver's license and insurance, they'll say that you were thick-fingered, that you had difficulty finding the driver's license and other information and handing it to them. And so then they have to have a good reason to arrest you after they've done this investigation. And so that's generally going to be based on, they frequently give people PBTs in the field, and that's a breath test at your car. They'll have people do field sobriety tests, and in the future, never do the field sobriety tests, never do any of the tests in the field, and don't answer any questions unless you've spoken with an attorney, and the attorneys advise you to answer their questions, and most attorneys won't do that. So after you fail the field sobriety tests, and everybody fails, and it doesn't matter what the cops tell you, when you see the police report, you're going to hear that you failed the field sobriety tests, that you showed clues of impairment. So then they've had a good reason to arrest you, and the next thing that they need to prove that you're guilty of driving under the influence is they have to prove that you were operating a vehicle and your blood alcohol content was over 0.08, or that you were affected by alcohol. Which reminds me, the first thing you have to do is you have 20 days from the date of your arrest to request a Department of Licensing hearing. And if you don't request that Department of Licensing hearing, then you're going to lose your license. In this case, with no prior history, you're going to lose it for 90 days. So it's really important to request that hearing. The officer should have given you paperwork for requesting the hearing, and he should have given you paperwork to request a waiver of the $200 fee. If you didn't do that, you can get online at Washington's Department of Licensing, go to the driver's license tab, and scroll down, and you'll see request a hearing. And so you need to request that hearing. If you don't request a hearing again, on the 60th day from the date you were arrested, your license will be suspended for 90 days. If your license gets suspended, then you can still get an ignition interlock license, but you have to get an SR22 high-risk insurance certificate. You have to pay a $100 license application fee with Department of Licensing, and you have to get the ignition interlock installed in your vehicle, which there's a variety of places who do that, and they charge from between nothing for the install to $50 or $100 to install the ignition interlock device, and then it's about $75 a month. So that's the DOL side. That's the arrest side. We charge $2,500 to represent people in first-time DUIs, so we would charge you $2,500. The expected outcome, it's absolutely impossible to predict. Depending on who stopped you and where you were, there are different types of evidence. So there's always going to be a police report, and there's always going to be a DUI packet. And the DUI packet consists of the information the officer got from you in response to questions. So you'll probably remember that he asked you, do you have any physical injuries, any reasons why you can't take the field sobriety tests? What time is it? How much have you had to drink? Do you think that your driving was impaired by alcohol? All those kind of questions. How much sleep did you get? And so the officer's asking a lot of information. He's recording the information. Now, if he does it completely accurately, and if it's a tough case, then it's hard to say where this would end up. I would personally expect that a case like this in most jurisdictions, you're probably not looking at being convicted of driving under the influence. That it would probably get reduced to something. We've had cases, similar cases, and again, I don't have the police report, I don't have the DUI packet. If it was Washington State Patrol, there's frequently a video, and I don't have the benefit of viewing the video, so there's a lot that I just don't know. But from what you've told me, with the set of facts you've given me, we frequently see these resolve in anything from pretrial diversion agreement to a negligent driving in the second degree, if there are some issues with the case, if the officer didn't cross all the T's and dot all the I's. They frequently resolve for a straight amendment to negligent driving in the first degree, and that doesn't have any license implication. It's a misdemeanor offense. The negligent driving in the second degree is like a pretty serious traffic ticket. It's generally a $500 fine. You would have to get an alcohol evaluation and follow up and victim impact panel. If the evaluation showed that you required treatment, then you would have to get follow-up treatment. That could be anywhere from 3 months to a year's worth of treatment. On the negligent driving in the first degree, there are no license implications, but you'd have to do all the other stuff, the evaluations, the impact panel, any follow-up treatment. There'd be about $1,000 in fines. If you were to resolve the case for a reckless driving, then there's a 30-day license suspension, in addition to the victim impact panel, the alcohol evaluation, follow-up treatment, $1,000 in fines, and all that kind of stuff. But I can't guarantee a result, because at the end of the day, what happens in the case is up to a prosecutor or a judge or a jury. It's not up to me, but that's kind of the range of how things like this generally pan out. Give us a call here at the office and come on in and talk to us. We do free consultations, and I can give you a little more information and talk to you a little bit more about how these things work and what you can expect. We offer convenient payment plans with a down payment and a credit card. We can do recurring billing that takes a little bit of money out of your debit card account or your checking account or your credit card. And that's pretty popular with people, but we can come up with a plan that works for you. I have 11 years of experience doing this. We have 2 former prosecutors here in the office. My business partner's been doing this for 5 years and has a lot of experience working for the state, representing people, and then of course here at the office. We've represented hundreds of clients in cases like this, and we do exceptional work. We would also include handling the Department of Licensing hearing, which is generally done over the telephone. You don't have to be there for that. Occasionally, we want you to be there because you have something to add to the conversation with the hearings examiner. And I think that kind of covers the high points of a DUI defense. And obviously, if you come in and meet with me, we'd spend a lot more time than this. But give us a call. At the end of this video, we're going to show you our address and our telephone number and email address. And I hope to hear from you. So thank you very much, Shaniqua.